On Christmas Eve, 1974, plaintiff Alice was born. Tragically, she entered this world with congenital limb deformities, that is, without limbs below her elbows and knees. Years later, believing that her birth defects were caused by his exposure to the chemicals used at his place of work, her father, plaintiff William, and she joined with other current and former employees of Defendant International Business Machines Corporation and their children in commencing litigation against IBM and numerous chemical manufacturers and distributors, the supplier defendants, which sold IBM chemicals used in the manufacture of computer microchips. Because their claims have been determined to be time-barred by the governing New York State statute of limitations, Ms. Fitch and her father move this court for leave to amend the complaints filed by them in the semiconductor litigation pending before this court involving approximately 190 other plaintiffs, so as to obtain the benefit of the Comprehensive Environmental Response Act of 1980 as amended by the Superfund Amendments and Reauthorization Act of 1986, and specifically which preempts the accrual date for toxic tort actions based on exposure to hazardous substances released into the atmosphere by environments as defined and permitted by such claims to accrue upon the discovery of the cause of the injury. In this case, presenting an issue of first impression for this state's courts, notwithstanding this court's sympathy for plaintiffs' plight because their claims do not come within the scope of the relevant provisions, their motion for leave to amend is denied. Mr. Fledging was employed by IBM at its New York facility from July 1973 until 1976. During that period, he worked in various capacities, some of which related to IBM's manufacturing of semiconductor chips. The process of manufacturing those chips, which was and continues to be done in a certain area known as a clean room, exposed Mr. Fledgling as to a variety of chemicals manufactured and sold to IBM by certain supplier defendants. Mr. Fletcher and Ms. Fletcher have asserted claims in 2 of the corresponding 22 complaints, theirs being included in the actions filed under the captions, which were commenced on August 13, 1996, and October 2nd, 1997, respectively. These cases and related cases were the subject of certain preliminary motion practice before other Supreme Court justices, resulting in rulings which included one designating the case as the first to go through full pretrial discovery and trial. Sometime thereafter, all of these actions were assigned to this court. Ultimately, the ruling case was resolved, and this court designated the next 8 cases which would be tried. As the fast-track cases have progressed through the discovery stage, both sides of the litigation have moved for various forms of relief. Among the motions made by the defendants was one seeking summary judgment dismissing plaintiffs' claims filed in Roughing the Second, on the ground that they were ultimately untimely asserted. In opposition to that motion, plaintiffs argued that they had set forth claims entitling them to the benefit of the more favorable accrual date, which would render their claims timely. Then, in response to defendants' reply papers in which they argued that workplace exposures are not covered, plaintiffs submitted a letter in which they contended that if their specific factual claims did not bring them within the scope, they were nevertheless entitled to rely upon that statute because of their use of general language to the effect that Mr. Fletcher was exposed to chemicals in the clean rooms and elsewhere. Because that letter constituted an unauthorized reply, it was not considered by the court, which rendered a decision and order entered June 27, 2001, granting summary judgment to defendants, dismissing plaintiffs' claims, the June 2001 decision. In a footnote, the court observed that it was not addressing the issue of whether plaintiffs may amend their complaints to assert claims, and that plaintiffs' entitlement to that relief would depend, of course, upon their ability to satisfy the requirements of a motion for leave to amend.